So the legal professions in the jurisdiction of England and Wales are divided into two historic monopolies. They're not actually monopolies now because they're not regulated as such, but until very recently they were. There are solicitors who had a monopoly on giving advice to the public, and there are barristers who had a monopoly on addressing the courts. And there are many more solicitors than barristers, so barristers have a kind of rarity cachet, but they also have a kind of elite lawyer cachet because their role addressing the courts means they are experts in the law as contrasted to solicitors whose role in advising clients means they're experts in sort of business sectors or whatever. So barristers are lawyers' lawyers, if you like. And when they get really good and really successful, when they get to the top of their profession, they can acquire a status which is where the label is Queen's Counsel, and it's literally conferred by the Crown. It means you're absolutely, pucker as a practitioner of law in the jurisdiction of England and Wales, and you get these letters QC after your name, and you practice from premises like that. That's in Lincoln's Inn. It's very pretty, and you wear a funny outfit in court, maybe, and you look like that, and you're the most authoritative person it's possible to get advice from. And a problem has appeared, or seemed to appear a few years ago, where QCs specialising in tax were giving dodgy legal opinions. It was raised by Margaret Hodge, who we heard from yesterday in the Public Accounts Committee hearing. She said that some of these tax QCs, so QCs who specialise in tax law have been giving dodgy opinions. A noted legal blogger who himself is now a tax QC said that he was seeing these dodgy opinions from tax QCs. And then there was a case where a tax QC had given himself bad tax advice and lost in the tax tribunal. His own tax avoidance scheme failed. So these people, I say people, the person who wrote the blog post about them refers to them as the boys, and they are all men. Not that all tax QCs are male. There are some female tax QCs, but the ones who are implicated in this behaviour are all men, the boys. So there's this problem. They're giving dodgy legal opinions. And that's what they look like. That's what a legal opinion looks like. It's a piece of paper with a name at the bottom, with the name of the QC. And that piece of paper will say, your tax avoidance scheme works, right? So these marvellous lawyers who are meant to be giving this excellent advice have been saying that and have been lying, right? So what's going on there? Why are they doing that? So here's a sort of flow chart that explains why that happens. It's about taking money from the public exchequer that doesn't belong to you, right? And that's what they're helping their clients do. So what happens is the taxpayer will enter into some transactions that create a potential tax advantage. It doesn't create a definite tax advantage, just a potential tax advantage. So they're creating tax risk. Because the idea is you file your tax return on the basis that you get the tax advantage, but you may or may not, right? So, but that tax advantage, if it came to court, would either fail, or you'd either get it or you wouldn't. So it's a kind of Schrodinger's cat type situation, right? The cat's either dead or alive, but you don't know until you open the box. Yeah? Right? So here's the flow chart. The cat's either dead or alive. The filing position is either correct as a matter of law or not. If it's correct as a matter of law, and it then gets challenged, then either way, your filing position has been effective and no additional tax is payable. If the filing position is not correct as a matter of law, and it's challenged, then it's ineffective avoidance and more tax is collected after the legal process, after the court process. But if the filing position is not correct as a matter of law and it's not challenged, then the taxpayer just gets to keep the money even though it's payable in tax, right? And a legal opinion from a tax QC saying that your filing position is correct as a matter of law, even though it isn't, is what gets you to that what gets you to that last place in the flowchart. It's what means that you can file saying that you get the tax advantage, even though you don't. It isn't challenged. You end up with public money in your pocket, right? So, so why do they do this? Why do they behave in this way? Well, I've suggested there might be a degree of toxic masculinity in play. I think there's also a lot of what we heard from Daniel, this idea that you take a zealous position on behalf of your person you're advising, when actually you should take a more moderate position. The zealous position is suitable for an advocacy role, not an advisory role. So anyway, there's also these discussions you might have about why this happens, but that's not what I want to. That's not what I want to get out of this. What I want to use these people as an example for. How much time have I got left? 5 minutes. That's good. Is to show how they can help us map this space of tax risk where they are at an extreme end of it. So if you go to a tax advisor, your tax advice, the tax advice you get from a tax advisor, can move you around this thing that I describe as tax risk space. And there's these, so along the x-axis, we've got the reduction in the amount of tax said to be payable. So that's your tax saving along the x-axis, right? And up the y-axis is the certainty of your filing position. So we start right there where we imagine we've got a very uncertain filing position. We're not trying to save any tax. We've just got a commercial situation. We don't know what the tax analysis is. A tax advisor could help us make it more certain. So let's say, for example, you take somebody on as a freelancer, but you're worried they might be an employee. So if they're an employee, you've got to pay some additional social security contributions or whatever. So you might go along to a tax lawyer and they say, right, well, what you need to do is put in some kind of no mutual obligation clause or whatever. That means they're definitely a freelancer as a matter of law, and you won't have that additional tax that you fear might be payable, won't be payable. So you put those clauses in. You're not trying to save tax. They always were a freelancer. You've just made the filing position more certain. So look, so you've gone from that position, that dot, that red blob there, you've gone up to a position of maximum filing position certainty, right? And that's a sort of non-abusive thing that a tax advisor might do, because they're not saving any tax. They're just making the position more certain. But they might help you save some tax. They might say, oh well, you could always instead of using that person to do that job there, which isn't subsidised by some additional R&D credits or whatever, you get them to do this job that is subsidised by additional R&D credits, and then you've saved some money. And if you actually get them to do the job that the legislation's trying to subsidise, then you save some money in tax, but you haven't reduced your filing position certainty. And that's going across the top line there, that horizontal line across the top. That's legitimate tax planning, right? But you get to a point where your tax advisor is starting to say, you could save some even more money. You could save even more money in tax if you do this other thing. But it might not work. If the courts get hold of it, if the tax authority notices, they might challenge it, and it might fail in court. So at that point, you're starting to create tax risk with your tax planning. So you turn the corner, you're now going back down again, right? And what these guys do is they help show where that process can end up. So that's where you've gone all the way down to a filing for a sort of near zero filing position certainty, where if the revenue authority, if the tax authority gets hold of sees what you've done, they will challenge it and it will fail in court. Yeah. So they help us. These people who are doing this very bad thing, that we could have that conversation about why are they doing it. What it does is it helps us map this space, because we know there's this extreme point. And there are questions that arise here. What about this middle space? You hear about. Sol mentioned companies who claim that they're compliant with the law. So we sort of think of them as having got more, sort of more higher quality, subtler, better tax advice that's maybe put them up here. That they've gone to these sort of big name branded advisory firms, and they've arranged their affairs such that they can realistically claim to have entered into structuring which is, as it were, legal, which doesn't create these exceptional levels of tax risk. So, what is the relationship there? And I suppose part of what I want to argue is that is not so clear. There's another element going on here, and a way to think about that is to think about the way in which think about the fact that as we get taken down here, as we get taken down that curve, it's still possible to do what we did right at the front of the curve. In other words, we can mitigate our tax risk, right? So an example, if you look at an example of someone who did a tax avoidance scheme down the bottom where those guys are doing their advice. There's a DJ, a British radio DJ, who did a scheme called Working Wheels, and it failed because it was structured around this proposition that he was a used car dealer on the side. Of course, he wasn't. He was a successful media personality. He never bought and sold used cars. He just claimed on paper that he had, so the scheme failed. But he could have mitigated his tax risk by actually buying and selling some used cars, right? And there's nothing stopping him doing that. So he could have done that. So he could have gone, using one of these highly abusive schemes that's advised on by one of the boys, he could have gone less far down the risk curve. But he would have saved the same amount of tax. Yeah? And what's really interesting about this is that the law that he tried to exploit to get this tax saving, doesn't exist to subsidize radio DJs buying and selling used cars. That's not what the law exists to do. And you'll find that exactly the same thing going on the level of big multinational corporate tax avoidance. So take the example of Amazon. Their UK Lux structuring relied on the proposition that the UK entity was doing one bunch of operations and the Lux entity was doing another bunch of operations. And that planning required those operations to be separate. And I think we can safely infer that the UK tax authority just assumed that they were separate, assumed that the tax risk being created was being adequately mitigated. Yeah? So assumed that we were up there with the good stuff. But in fact, in some non-tax litigation, it turned out that Amazon Lux and Amazon UK had there was no commercial distinction between the operations of the two companies. They were basically being run as a single company. So they hadn't adequately mitigated their tax risk. They were, in fact, right down where the boys would have put them. And in the same way, the relevant legislation does not exist to subsidize the separation of operations in multinational companies between two jurisdictions. So even if they had mitigated their tax risk properly, that saving still wouldn't have been something that the legislation provided for. So I think that in conclusion, there are people in this room who are quite familiar with my sort of risk-based and the tax risk mining analysis of tax avoidance. And if you've got it thus far, the conclusion is that the next level is to understand the role played in the analysis by the mitigation of deliberately created tax risk. Thank you very much.
Ah, the punchline. Thank you very much.